All right, we are calling to order the 187th meeting of the Massachusetts Gaming Commission at our offices at 101 Federal Street. It's now about 1 o'clock. We will start as usual with approval of the minutes. Commissioner McDonald.
Yes, I move that the
Mike.
that the minutes of the March 22nd, March 24th, and March 29th, is this right?
No,
No, it's not, I'm sorry, I'm on the wrong,
this one.
yes. The minutes of the meeting of April 14th, 2016, be approved subject to any corrections, typographical errors, or other non-material matters.
Second,
Second.
conversation? All in favor?
Aye.
Opposed? The ayes have it unanimously. Next is administrative update with Executive Director Bedrosian.
Good afternoon, members of the Commission. You will see I am seated over on the other side today. That recognizes the significance of what will be happening with item 4A in the role Mr. Ziemba and General Counsel Blue will play. Mr. Moore, to my right, will shift into my seat, and I will go to the back and attend the meeting from behind. This is obviously a busy week for the Commission. In addition to today's hearing, we have deliberations on Region C down at the Shaw Center in Brockton, scheduled for tomorrow, Wednesday, and Thursday, and back here on Friday if necessary. I will just tell you, staff is working very diligently on preparing all the materials for the Commission, and we intend to be ready. I just have one suggestion, Mr. Chair, on item number 4, the legal division. You may want to consider doing items B and C, which are relatively quick, before getting to item A, which is the Win 61 decision.
Yep. Anything else? Okay, so we will do that since 4A is the big item. 4B, Commissioner Zuniga, I believe you have the paperwork.
Yes, I do have a motion to read into the record relative to the promulgation of 205 CMR 116, persons required to be licensed or qualified, and its associated amended small business impact statement. And later I'll be doing that separately for 205 CMR 134, the licensing and registration of employees, vendors, junket enterprises, and representatives and labor organizations. If I can just briefly touch base with our general counsel, these are in final form, if I'm not mistaken.
These,
General Counsel?
yes, these regulations have gone through the process. We've had the public hearing. The only piece we have left is to file them for final promulgation along with the amended small business impact statement. So they have come before you. We have received comments. We've made, I believe, no changes since the last time they were before you. And we did hold our public hearing, and we did not get any comments at the public hearing on them. So they are ready to go through to be finally promulgated.
All right. So if there's no further questions or comments, I would move that the Commission approve the amended small business impact statement and final version of 205 CMR 116 as included here in the packet, and authorize staff to take all steps necessary to file the regulation with the Secretary of the Commonwealth and complete the regulation promulgation process.
Second?
Second.
Any discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
Similarly, the second set of regulations in the packet are 205 CMR 134, certain licensing regulations, and I believe they're in the same status at final promulgation stage. We've had the hearing, and we've discussed them before.
That's
And they're
correct.
ready for final promulgation.
Okay.
So I would move that the Commission approve the amended small business impact statement and final version of 205 CMR 134 as included in the packet, and authorize staff to take all steps necessary to file the regulation with the Secretary of the Commonwealth and complete the regulation promulgation process.
Second.
Discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously. Okay, we will move on to 4A, the WIN Section 61 decision. As has been in the past, since neither Commissioner McDonald nor I participated in the original vote, in the original decision-making on Region A, he and I will not participate in this topic. And as I've done in the past, I'm going to ask Commissioner Zuniga to conduct this portion of the meeting.
Thank you. Thank you, Mr. Chairman. I'm first going to turn it over to General Counsel Blue to perhaps give us an update on the changes since we last talked about these, and the process since we last saw this document, and let the commissioners ask questions if we have.
So thank you, Commissioner Zuniga. Mr. Ziemba will have some overall remarks, but I just wanted to say that today we are bringing before you the final version of the draft Section 61s for the WIN project. You will have in your packet a red line copy and also a clean copy. These are the product of a great deal of thought and work by our consultants and by Mr. Ziemba to try to get into this final form what the mitigation is that's required under MEPA and how that should be addressed. So I appreciate all the work that folks have put into this, and we've taken our time to get there, but we think we've gotten all of the issues addressed and appropriately for the project. So I'll let Mr. Ziemba make some remarks. We have our consultants here to answer any questions, and obviously Mr. Ziemba and I can answer questions as well.
Thank you, Catherine. Commissioners, as you're aware, on August 28, 2015, the Secretary of Energy and Environmental Affairs determined that WIN's second supplemental final environmental impact report adequately and properly complied with MEPA. In the certificate issued by the Secretary required enhanced public review during the development of Section 61 findings by both the Massachusetts Department of Transportation and by the Gaming Commission. Included within the mandated enhanced review were the publication of draft Section 61 findings by MassDOT for public review and comment, and a 15-day comment period. MassDOT was also required to have a public hearing on the draft findings. Following the hearing, the certificate states that MassDOT will publish its final Section 61 findings. MassDOT has since done so. The Secretary also required an enhanced process by the Commission pursuant to the certificate MGC's issuance of Section 61 findings. We were required to consider and revise as appropriate its draft Section 61 findings included in the SSFEIR. The MGC Section 61 findings shall include or include by reference the MassDOT Section 61 findings. We're including those. Consultant hired by the MGC will make a public presentation at MGC Meeting and provide recommendations regarding additional conditions that could be added to the draft Section 61 findings. We have already had a presentation. We'll have further presentation about additional conditions that could be added today. MGC will solicit written comments in the draft Section 61 findings and will hold a public hearing. We have done both of those in the recent past. The draft Section 61 findings and the consultant reports will be posted on the MGC website. We did that. We also published them in the Monitor. And we also submitted copies of our comments, copies of the comments of the draft for comment to those that had interacted with the process. And then compliance with the Section 61 findings and the conditions of the gaming license will be part of a regular quarterly review conducted by the MGC. That will occur after the Commission approves the Section 61 findings. One thing I'll note is that the certificate also required the establishment of a long-term planning group to review both transportation and development concerns in the region. That pursuant to the certificate, the establishment of that regional working group was designed to proceed on a separate and distinct track and will also include significant opportunities for consultation, public review, and comment. That is underway. That group has met quite a number of times, and they are in the process of developing their plan for public comment as they develop their final plans. Notably, that group includes MassDOT, MAPC, CTPS, the cities of Boston, Everett, Somerville, and WIN is also an observer, a participant, an observer. The Gaming Commission is also an observer, also Congressman Capuano's office, and Executive Office of Housing and Economic Development. how could I miss that one? I'm sorry. In the Attorney General's office. Thank you, Catherine. Very important one. Rick Moore of City Point Partners will provide a brief highlight of some of the changes that have been made since the initial MassDOT Section 61 findings, the draft, and will discuss some of the concerns that have been raised as part of our process and how we've addressed those. Before Rick begins his presentation, I just wanted to highlight one provision that's included in this latest draft for your consideration. If you turn to page 57 of your draft, I'll let you turn to that. So if you take a look at page 57 of the draft, the draft states that when, at the very bottom before the beginning of the footnotes, it states that WIN shall use its best efforts to work with the MBTA, MassDOT, and DCR on any future plans to create mass transit opportunities that serve the gaming establishment, including, without limitation, working with the MBTA, MassDOT, DCR on right-of-way issues. WIN shall consider making a reasonable contribution as may be determined by the Commission to the cost of implementation of such mass transit opportunities. Indeed, there will be quite a bit of discussion of mass transit opportunities as part of the regional working group, and we think that this provision included in these draft Section 61 findings reflects the true spirit of policy debate that will go on in that regional working group. But we also do note that this sentence is also included within the overall context of what the Secretary required as part of the certificate. The Secretary required that the enhanced public review process that I just mentioned, and the Secretary also required as a separate track the long-term working group process to take a look at issues within the region, both transportation and economic development issues. So in keeping with that, we have required that WIN make a consideration of mass transit opportunities that would flow from the working group. And many of these ideas have been around for quite some time. Some are new, but at the end of the process, some of these opportunities could provide a substantial improvement to the WIN property, and we think that this is a proper request. We also do note that in the prior 56 pages of this document, that is consistent with the mitigation that WIN is required to make pursuant to Section 61 to mitigate its impact. Some of the long-term planning opportunities could improve the area, improve transit opportunities, improve transportation opportunities, but the prior 56 pages are designed to mitigate the impact of the WIN facility. And there, as we know, that there have been significant review at the MEPA level at MassDOT. MassDOT, just as I mentioned, issued its Section 61 findings, and today we'll consider further findings. One other thing I will mention before I turn it over to Rick is that these findings should be placed in the context of the significant mitigation that is required of all licensees, and specifically WIN. They've entered into surrounding community agreements with many communities. And then in tandem with that, the Commission obviously has the authority to administer further funding as part of the Community Mitigation Fund program. There will be significant dollars, over $11 million based on projections from the WIN licensee each year to try to address future impacts that may result from this facility. So in tandem between the Section 61 findings, the consideration of any further opportunities as part of the regional working group, the surrounding community agreements, the Community Mitigation Fund, we think that there is very significant mitigation that is being put forward by the WIN licensee and by the Commission. In addition, the Commission also has the ability and has retained the ability through its draft Section 61s and items included in this agreement, in this Section 61 findings, to require further mitigation of the WIN licensee under a number of different circumstances, such as if the traffic and transportation projections that we have all taken a look at do not come to bear. If the situation is is the worse than expected, and there's provisions included in the Boston Surrounding Community Agreement that provide a specific threshold to how that should be monitored. The commission has retained the ability through its own regulations to review, monitor, and make changes to mitigation requirements by wind in the event that, hopefully it won't come to pass that the situation is any worse than projected in terms of traffic or other circumstances. Rather long-winded beginning, but let me transfer this over to Rick Moore and Frank Tramatozzi.
If it's okay with Mr. Tramatozzi and Mr. Moore, I do want to emphasize, and maybe I have a question on a couple of points you made, and maybe they'll touch on a little later. But perhaps for the record, we conducted this enhanced review, this enhanced process, which included a public hearing 20 days or so ago, a little bit over 2 weeks.
That's right.
We had public comment before and all the way through, was it last week on Wednesday?
Through the 19th.
Through the
I
19th.
believe.
I know Chairman Crosby makes a point of highlighting this, so I'll make it now. The commissioners all go through all those public comments. The staff, of course, goes through them. We received a lot of comments in this case, very thoughtful, many of them, and a lot of that has been taken into account as we get into this review. Will Mr. Moore be getting into our ability to require further mitigation, or is that something we can later come back and?
Yeah, why don't we perhaps have Rick's presentation? He'll
Okay.
talk a little bit about monitoring, TDM measures and the like.
Great.
And then we can
We can
answer
discuss.
any questions.
Yeah.
Thank you, John. Commissioners, Frank Tramatozzi, as John mentioned, is with me this afternoon. Let me just go back a little historically to bring you along in this whole Section 61 finding. In the MEPA process, as a result of the final MEPA process, there is a draft Section 61 finding issued by the Secretary. So that's sort of the first touchstone. And then that is looked at by each of the agencies. Mass DOT looked at it, they've modified it slightly, and they've issued their final Section 61 finding, which, as John said, is now officially submitted, and that has been compared to your draft Section 61 finding to make sure there's consistency and there's no inconsistency in the two. From the MEPA draft Section 61 finding to the draft that you saw several weeks ago, there were two additions that were made that we talked about at the previous meeting. One was the lighting plan for Charlestown, and the second one was an additional location in Somerville that was added to the monitoring plan, and that was at Broadway and Lombardy Way, and that was to deal with any potential unforeseen issues of backup traffic from Sullivan Square into Somerville, and it was raised in the Somerville comments. Those have not changed. They're still in the current document. The document you are looking at now has one additional change in the monitoring program, and that adds the William Street and Chestnut Street intersection in Chelsea. And that was raised by the city of Chelsea to address the potential issue of cut-through, primarily taxi-type cut-through from the airport to the casino. And that intersection would be along that cut-through route. So it'll be monitored, and if indeed that's an issue, there'll be ability to address it. In addition to that, based on the comment letters that came in, there were three what I would call clarifications in the document. The first clarification had to do, again, with traffic monitoring and how it's done. The Attorney General raised some issues about clarity and exactly how that monitoring plan would be undertaken. So there's been some clarification language added that indicates that the traffic, should be counted at the peak hour on Friday afternoon and Saturday. And those are the times when the traffic will be counted and compared. And then the comparison that triggers any re-looking at the intersection was identified in the City of Boston Surrounding Community Agreement, and is further iterated in your agreement, which identifies thresholds of 10% over the projected traffic from the project. That would trigger a relook, and over 80% of the traffic that goes through Sullivan Square. And I think, without getting into the exact nomenclature, the language in there attempts to clarify those issues, and so that when the traffic monitoring is done, it'll be clear, and when you compare what you get in several years once the casino opens, with what they projected, you'll have a good basis of comparison. The second clarification deals with the water transportation. There was some discussion or some implication that the water transportation effort by WIN was going to be decreased below what was in the supplemental final draft EIR. That's not the case. The language in the supplemental draft EIR, which was approved and in the Section 61 finding, is in your Section 61 finding. There will be 3 boats that operate at about 10-minute headways during the peak hour to deal with that estimate of taking approximately 6% of the total traffic by boat to the casino. And so that language has been expanded and clarified in the Section 61 finding. And then the last clarification has to do with highway safety audits. At all of these intersections that require improvements, Mass DOT requires that highway safety audits be done. These are fairly detailed analysis of safety issues, and the recommendations are generally put into categories of low, medium, and high, if you will, and typically the low and medium improvements, which are typically related to lane striping, signage, signal timing, should be included in any of the design plans for those intersections. It makes sense. It's standard procedure for Mass DOT. And the clarification in your document really acknowledges the fact that these highway safety audits have already been done. They were submitted by WIN on March 10th. And the document acknowledges that and identifies the level of improvements that need to be incorporated into the plans for these intersections. Again, it's more of a language clarification change. There's no fundamental change in the philosophy of the mitigation. Now, those changes deal with what John referred to, the first 56 pages of the document, which in total mitigate the impact from WIN. And I believe it's the last 2 or 3 pages of the document that deals with the so-called long-term plan, which is separate from, as identified by 2 secretaries, from the Section 61 finding and the mitigation for WIN. And there are 2 conditions that John mentioned, I'd just like to reiterate, that are in that piece that deal with the long-term plan and how WIN is to interact with the long-term plan. Keep in mind, as we talked about several weeks ago, the long-term plan is being managed by DOT, and it's got an 18-month horizon to look at regional issues with a focus on Sullivan Square. The City of Boston, in parallel to that process, is coming up with a 25% design for Sullivan Square. The immediate improvements to Sullivan Square that will go beyond WIN's mitigation and actually piggyback on WIN's mitigation to deal with the whole square issue. That 25% design should be done well before the DOT study is done. And so the solution there, whatever that solution may be, will be funneled into the long-term plan and analyzed as the various other regional issues, whether they're transit or other roadway intersections in the area, whether it be a Wellington Square or whatever transit issue. So to some degree, the City of Boston, not to some degree, the City of Boston will determine what the long-term plan is for Sullivan Square. And the language in the Section 61 finding, although it refers to the long-term regional plan, says that the Commission has the ability to reopen the Section 61 findings if they feel that the long-term plan, if they feel that WIN is not contributing their fair share to the long-term plan. Now, the language further goes on to talk about in and around Sullivan Square. And I would interpret that as to be essentially the plan that's coming out of the City of Boston. That will be the solution to Sullivan Square. And if when I would advise you to apply the fair share issue, it would be to that long-term plan that comes out of the city of Boston that will fold into the regional plan. But the point here is that the commission does have the ability, in the Section 61 finding, to reopen the Sullivan Square mitigation. And keep in mind, that mitigation is about $11 million now for the short-term plan, about $25 million for the long-term plan, and then there's several other pots of money that could be contributed to Sullivan Square. All that is part of WIN's fair share. If for some reason along the way, based on Boston's decisions at Sullivan Square, or potentially the regional planning decisions at Sullivan Square, if you feel that those monies are not equal to WIN's fair share, you have the ability to reopen the hearing. So that's the first point. Yes.
Can I ask you a question?
Yes.
We talk about proportionate or fair share. We haven't talked about a determining factor. Could you elaborate on that?
Yeah, a good question. What is fair share? I think from a transportation point of view, one way to look at it, and the way we've looked at it in the past, is the percent of traffic that WIN is putting through Sullivan Square in relationship to the other traffic that's in Sullivan Square. And if you'll recall, we've talked about this before, on a Friday afternoon, WIN puts about 8% of the traffic in Sullivan Square. On a Saturday afternoon, it's about 19%. In the morning, peak hour, it's minimal. So the question is, one of those numbers is operative, or some combination of those numbers gives you a sense of what their fair share is. And then presumably, you would compare that 11 million, 25 million, plus any other monies that go from the city of Boston or the commission or DOT that gets money from WIN. Any of that money that goes to the Sullivan Square would be, attributed to their fair share, and you have to make a judgment whether that is a fair share.
Thank you.
Is that okay?
Yes.
The next piece of the long-term plan cooperation by WIN deals a little bit broader than just Sullivan Square. It says that WIN will cooperate with recommendations, and particularly related to any right-of-way issues that may come up in terms of particularly transit corridors that may come up in the planning process in and around the casino. Any new stops, for instance, on the transit line that goes right by the casino, and that they would cooperate if there was a plan that required right-of-way acquisition, that WIN would cooperate, obviously, particularly if it's on their property. And the second one has to do with cooperating with mass transit. Gets a little bit beyond the actual roadway improvements and the car issues on Sullivan Square, and deals with the broader transit issues. And they will consider contributing to any transit mitigation that might help them, that the commission identifies as an improvement that would help WIN, and suggest to WIN that this is something that they should consider. So there's sort of a two-barrel requirement of WIN. One is the fair share of the Sullivan Square improvements, as I see it, and the second one is the cooperation with the more regional issues, most of which will probably deal with transit-oriented development.
On that second point, Rick, you were alluding to transit possibilities, as was John earlier. Let's say if there was a stop in Everett, an additional stop in Everett on the commuter line that goes by the property, like Everett has wanted it for years, I suppose. That would have some beneficial effect to WIN, for all intents and purposes, and that gives that starts this notion of be considered for future additional mitigation.
Absolutely. Yeah, that's a perfect example.
Okay.
Yeah.
Rick, we had a number of those kind of transit-related suggestions provided to us in some of the commentary. I think Mr. Salvucci weighed in on some of the transit components being part of an urban ring plan. Is the urban ring plan being folded into the long-term working groups discussions, considerations?
Yes. The long-term working group will look at, there's been very, very many alternative urban ring plans. The current urban ring plan, which the DOT is carrying, although it's not funded and it's not on their list of projects. The one that they have sort of keep going doesn't go near the casino. It goes through Wellington Circle.
Okay.
But there have been other options to consider certain types of transit along that rail line that Commissioner just mentioned. And it's my understanding that the DOT working group will not be confined by any prescribed previous plan. They'll look at whatever good ideas come along, and they may or may not involve the wind site.
Okay.
Rick, I know rapid bus transit was another. Could you just elaborate a little bit on some of these mass transit ideas or, pieces of this that may be part of this?
Yeah. The urban ring has been around, as John said, for many decades. And the idea is to start at Logan Airport and basically do a ring around Boston, through Chelsea, through Somerville, through Cambridge, into the Longwood Medical Center, and all the way back to Logan. And the idea is to have, I guess the current idea is to have buses that travel on various different modes of transportation, or light rail that travel on very different modes of transportation. In some cases, they're on a rail. In some cases, they're on a rail right-of-way on a road. In some cases, they're on a separate dedicated bus lane on a road, which just the bus travels. And in some particularly challenging places, the buses may actually go out into normal traffic and use the normal roadway. And it changes because of so many issues, as you can imagine, through that congested area, whether you have right-of-way, whether all those issues. And this has been a project that's been on the books for many years. DOT still has it on the books. It is not in their current list of projects and funded, but they view it as a long-term benefit. And in fact, the first link of that from Logan into Chelsea is underway. So this is not completely pie-in-the-sky stuff, but it's very, very challenging given the right-of-way issues that are available.
Can I ask a question on the 25% design process here in parallel with the long-term working group? Ballpark, what is that date for the 25% design? Just give me an idea.
I would think 9 months, but I would not, I'm not taking that from the city of
Sure.
Boston. That's my,
It's your date,
Yeah.
nobody's gonna.
yeah. But keep in mind that there'll have to be a number of, public hearings.
Yes.
It's not like they're just taking the preferred plan and moving it to 25%. They're going back and doing some reanalysis. So it will take some significant public interaction to build a consensus on a long-term plan.
Yeah, I guess that was going to be part of my second question. They're looking at a number of alternatives, correct? And all of that has to be vetted through the public process.
Right.
Yeah. But it's fair to say that that will be done prior to the end of the regional working group, because that has a timeline of about 17 months. Is that a fair statement?
Yes. That's the profound hope.
All right. Good.
My comments are done, so I'll answer any questions any other questions?
Well, we jumped in all the matters. Additional questions from commissioners for Mr. Moore?
I just had one, maybe, and I don't know if you can get to it, but, the question about the boat traffic, I think the new language says at least 3. So if wind shows at some point, they can find a way to, move more boats in and out to help ferry people over to the site, that's a possibility. But it's no less than 3, correct?
That's correct.
Well, I did have a couple of questions. I think we alluded to them already in the presentations, but maybe for the record and for my benefit, it might be good to emphasize them. We received a letter from the city of Somerville as part of this process, which said that the panel of 3 arbitrators had reached a favorable decision to Mr. Wynn, to the licensee, but there was the dissenting arbitrator that raised a number of issues that, according to the city, have already come to fruition. If you could please, if anybody could speak to those, whether, how they have come to fruition and whether they have been addressed in this draft.
Sure, let me let Rick. We took another look after the comments we received from Somerville. We took another look at the arbitration proceedings, what was put forward, and a look at those intersections. I'm going to let Rick go into that.
Okay.
The Somerville, their expert was I believe, the planning director from the city of Somerville, who spoke about a report that was done by MIT. The report was never submitted, so nobody has ever seen the report. Presumably it was done, but it's not on the record. Further, the report presumably indicated that there was an impact from the project on certain intersections in Somerville. I believe there were 9 intersections that were identified. And that's not surprising because that's exactly what Wynn said, that if you just built the casino and did no mitigation, there would obviously be impacts on intersections in the city of Somerville. What MIT did not go and do is look at the impacts if you built all the mitigation that Wynn is proposing. And of course, Wynn did that and suggested that there would not be any impacts. Further, Wynn showed the number of vehicles that were going through a number of these intersections, and it was on the face of it, de minimis, traffic at these intersections, except for 3, which were, by the way, included in the MIPA document and analyzed fully through the process. So in our interpretation of the traffic, there was really no substantive information. In fact, quite the contrary. There was a great deal of information that suggested that these intersections had no impact from the casino. And if they did have some minor impact, they were mitigated. Nevertheless, it appeared that the one intersection we talked about, which might have some backflow from Sullivan Square, we did add that to the monitoring plan. So we could not find really any credible evidence to support their contention that there was any traffic impact in
Great.
Somerville.
Great. And that intersection is I wrote down the Chelsea intersection. That was discussed in the last time you were before us, that additional intersection in the city of Somerville.
No, the intersection in Somerville is the Broadway Lombardi intersection.
Yep. Did we discuss it last
Right,
time?
yes.
Yep.
Yeah.
Yeah, and it's now included in the draft findings
It was actually in your draft the last time.
last time around. Okay. Yeah, just the comment from the city came right after that, but never mind. And you also included the Williams-Chestnut intersection, which is this potential cut-through from people or taxis, let's say, from Logan Airport to the site. The language in the document says if there's a significant increase, that we would look at it. Can that be measured? That the word significant, appears a bit of a judgment call.
Yeah.
Could we just?
I think it was left that way because we're not talking about total traffic necessarily. We're talking more about a piece of the traffic. And I think, when you look at the monitoring plan and then you look at the operation of the intersection, I think at that point it'll be a judgment call that the traffic experts and the commission can make. and determine what is significant, rather than prescribing a number that may not be appropriate at the moment.
Okay.
I also believe Chelsea is looking at that entire corridor and is doing an evaluation of the entire corridor. So there'd be quite a bit of information focused on that corridor in the next couple of years.
Okay. Any other questions for
Just a,
Mr. Moore?
kind of a, looking at this in totality, obviously, you've looked at all the comments as we have, and you've incorporated those that you think are appropriate into the changes here. It sounds, although you didn't say it from your recommendation, that that it's your expert opinion that these changes will, in fact, mitigate obviously, all of WIN's issues, and looking to the future with the working group, are appropriate for that working group as well.
Yeah, I have rarely seen a mitigation package as thorough and as extensive as this for a project like this. I think this is a very commendable job that the commission's doing, and the mitigation is certainly appropriate, and in many cases exceeds the so-called minimum standard that MIPA would require. So I would recommend that you approve the Section 61 findings.
Rick, just one other question. We had various comments, or the leading comments that came in from the abutting neighbors in Charlestown have to do with lighting, and we've had constant communications about how tall the facility is going to be. As I understand it, the height of the facility is not something that's referenced in Section 61 findings. And a lighting plan is a local approval. It's not the approval of a state body or this commission, but, you know, I would expect our friends at WIN are sharing that illumination plan, as much information as you can get out of an illumination plan with the folks in Charlestown. But my assumptions on the height and the local control over the illumination plan, are those correct?
Yes, and the height issue is really, typically it's a zoning issue, and the Chapter 91 license is a de facto zoning process, and that's where the height issue is fully explored and dealt with.
Okay.
Height, shadow, and
Massing.
wind
Right.
primarily, and lot coverage. So those are typically zoning issues.
You know, I was going to ask this question later, but since you mentioned Chapter 91, I'll ask it now. If we proceed with a favorable vote towards finalizing these Section 61 findings, the licensee has the ability to do what? Of course, with the background of the Chapter 91 appeal by the city of Somerville, that is a separate permit.
Well, if you recall, the Chapter 91 license jurisdiction is related to the water. And the jurisdictional line cuts right through the middle of the WIN site, so it actually doesn't cover the entire site. So technically, WIN, even under the appeal, while it's still under appeal, could work outside the jurisdiction of the Chapter 91 license. That's the half of the site that's farthest away from the river, obviously. You know, practically speaking, from a construction point of view, that doesn't make a great deal of sense, but certainly they could do some work that's outside that jurisdiction, at risk of the outcome of the Chapter 91 appeal.
Okay. So they would be.
Could I elaborate? Just wanted to
Yes,
follow up, and
yes, please.
just purely for informational purposes, because this will matter going forward. Where is there, I assume, is there a setback from the water? Is that what determines the line, or how is that line determined?
It's
and where
based
does-
on a historical high tide location, so you look back at old aerial photographs, old, you know, maps from the Revolution, and you draw, you know, the old high tide, and typically around Boston, most of it's been filled, so the high tide line surprisingly can be quite a distance from the current, bulkhead or current shoreline.
Okay.
And so it's a little history lesson of the site to come up with the line.
All right, so that's how it gets into
That's
line.
how
I
it
couldn't
gets.
figure out how it gets so far into the land. So the high tide mark, whatever the high tide mark was, quote, originally, whenever that was, what about before the glaciers came?
Well, I think we're dealing in hundreds of years and not in tens of thousands of years, but good point.
All right, thank you.
So the licensee would be, it would be up to them, really, for all intents and purposes, to proceed subject to that constraint of that Chapter 91 permit.
Yeah, I think they'd want to talk to the city of Everett and you folks, but yes, they should be able to
Right.
do work.
Right.
For example, the access road, the service road,
Yeah.
that's outside Chapter 91.
That's it, right. And I understand there's some utility work that they would, there's utility work in that access road that
But
might be really
that's-
good to do out
exactly.
of the way.
Exactly.
Right, okay. All right, thank you, Mr. Moore and Mr. Tromtasi. Any additional comments or questions for anybody here? Well, if there are none, I have a motion. I have two motions, actually. I'll just explain them and then read them into the record. We will vote to adopt the Section 61 findings as previously discussed here, but we also will be voting later or soon after to take the final agency action on the Region A as part of our Category 1 gaming license, which is why we've divided these into two votes. I will read them into the record and ask for a roll vote soon after. I move that the Massachusetts Gaming Commission find pursuant to Chapter 30, Section 61, and 301 CMR 11, subsection 12.5, that all feasible measures have been taken to avoid or minimize impacts to the environment of Wynn Mass LLC's Everett project for the reasons stated in the proposed Section 61 findings that are attached here in the packet. I further move that the Massachusetts Gaming Commission adopt the proposed Section 61 findings regarding the project pursuant to the Massachusetts Environmental Policy Act, MIPA, Chapter 30, Sections 61 through 621, Chapter 23K, Section 15, subsection 12, and 301 CMR 11.12, as well as 205 CMR 120.02 in the form attached here too. I further move that the Commission authorize Commissioners Cameron, Zuniga, and Stebbins to execute the Section 61 findings in the form attached here in the packet. And lastly, move that authorize the Commission's General Counsel to take all necessary procedural actions to effectuate the findings in accordance with the Environmental Policy Act, the Gaming Act, and the regulations implementing each statute. Is there a second?
Second.
Any further discussion?
I would just like to say, for the record, that anyone here voting, I have worked extensively with Mr. Moore and Mr. Tremontosi with all matters of mitigation and, really have asked a lot of tough questions, really come to understand their expertise, and I really do have faith in the analysis they've done. They're very, very thorough. They're very familiar with numerous projects throughout the Commonwealth and the kinds of work that was done by those projects. And so I am just stating for the record that I think that they served us well with their advice and will continue to do so. This is an example of that work.
Yeah, it sure is. Not only our consultants, our staff, General Counsel, Lou,
Yeah.
John Ziemba, others, Anderson and Krieger, our outside counsel, and frankly, WIN, the people from WIN have done a lot of work relative to getting ready to this point. It's not easy to get to this point from their perspective, as it is not necessarily for ours, for us either. But there's been a lot of work that has happened in the last months, really. Couple of years, if you count when you started. And this is really a testament to that work. Like Mr. Moore, I have not seen a project with this kind of mitigation before, not in the Commonwealth and in my limited construction experience, not anywhere else. It's really a remarkable set of mitigation. There's a second. All those in favor, I'm going to roll call. Commissioner Stebbins?
Yes.
Commissioner Cameron?
Aye.
And Commissioner Zuniga votes aye. The ayes have it unanimously. There's a second vote that I'll read also into the record. This vote is to take final agency action on the Region A Category 1 gaming license. Whereas the Massachusetts Gaming Commission has found that Chapter 30, Section 61, and 301 CMR 11.12, subsection 5, that all feasible measures have been taken to avoid or minimize impacts to the environment of WIN Mass LLC's Everett project. The Executive Office of Energy and Environmental Affairs, number 15060, for the reasons stated in the approved Commission Section 61 findings regarding the project attached here too. Whereas pursuant to 205 CMR 120.02 subsection 1, and following the Secretary of Energy and Environmental Affairs certificate, determining that the second supplemental final environmental impact report, SSFEIR, is adequate pursuant to MGL Chapter 30, Sections 61 through 62H and 301 CMR 11, and after 60 days have elapsed following publication of notice of the availability of the SSFEIR in the Environmental Monitor in accordance with 301 CMR 11.12 subsection 4A and 11.15 subsection 2, the Commission shall and hereby does reconsider the conditional license and shall either affirm, limit, condition, restrict, revoke, suspend, or modify the conditional license in the discretion of the Commission. Now, therefore, I move that the Massachusetts Gaming Commission take the following final agency action regarding the Category 1 gaming license for Region A. 1, grant to WIN Mass LLC the Region A Category 1 gaming license for the project pursuant to General Laws Chapter 23K and the Commission's regulation, including 205 CMR 120.02 subsection 1, subject to all of the terms and conditions stated in Exhibit 2 to the conditional agreement to award the Category 1 license in Region A to WIN Mass LLC, dated September 17, 2014, and the Commission's motion and vote dated November 6, 2014, that was meeting number 138, transcript page 51, as amended by the Commission's motion and vote dated February 4, 2016, that was meeting number 178, transcripts pages 30 and 31, as further modified and amended by the terms and conditions, mitigation measures, and other requirements identified in the Commission's Section 61 findings for the project. 2, incorporate by reference pursuant to 301 CMR 11.12, Section 5B, and 205 CMR 120, subsection 1, the Commission's Section 61 findings into Win Mass LLC license for the project and require, as a condition of the license, that Win Mass LLC comply with the terms, conditions, mitigation measures, and other requirements identified in the Commission's Section 61 findings. And finally, 3, require as a condition of the license a regular quarterly review by the Commission of compliance with the Commission's Section 61 findings and the terms and conditions of the license. You can see why I needed to read that.
I'll second.
There's been a motion and a second. Any discussion? All those in favor, Commissioner Stebbins?
Aye.
Commissioner Cameron?
Aye.
Commissioner Zuniga votes aye. The ayes have it unanimously. Thank you very much. Thank you very much.
Thank you.
Thanks, Frank.
That concludes.
Thank you, Commissioner. That's Section 4A. Congratulations to our licensees. Thank you for all your hard work, everybody. Is there any other business that was not anticipated from anybody? Do I have a motion to adjourn?
So moved?
All in favor?
Second.
Aye.
Aye.
Ayes have it unanimously. We are adjourned.